Hello, welcome to the self-learning platform by Dr. Sushma Singh. Today we start Unit 8, UN System, Peacekeeping, Peacemaking, and Adjudication. We are going to discuss adjudication. Adjudication or judicial settlement is the process by which a dispute is settled by a third party who is invested with authority or jurisdiction to decide by determining the fact at dispute between the parties and applying the relevant law after giving each party equal opportunity to present their respective cases in accordance with the authoritative rules of procedure. Within the state, the judiciary exercises a sovereign function and adjudicates disputes between private parties and executive. It may also adjudicate challenges to laws enacted by the legislature, testing them on the touchstone of the Constitution. The international community is radically different from the state system. There is no centralized executive, and states themselves perform the functions of obeying the law and enforcing the law. There is no centralized legislature, and laws come into existence by agreement, by practice followed with the conviction that it is obligatory to follow it. There is only a very rudimentary judicial system. Let us examine the International Court of Justice and other existing judicial tribunals. First is the International Court of Justice. After World War I, the League of Nations was established, and following it, the Permanent Court of International Justice PCIJ. With the outbreak of the World War II, the League of Nations became practically defunct. The United Nations was established after World War II, with the ICJ forming one of its principal organs in place of the PCIJ of the League period. The status of the ICJ was so designed that a continuation is maintained between the PCIJ and the ICJ. The court consists of 15 judges elected by the General Assembly and the Security Council by simple majority, voting separately but simultaneously. Each judge is elected for a term of 9 years. Every 3 years, 5 judges retire and their places are filled by election. The qualification to be a judge is that he should be of high moral character and qualified to be appointed to the highest judicial office in his country. Nominations of candidates for election are made by governments, but by national groups in the Permanent Court of Arbitration, established by First Hague Peace Conference 1899. The ICJ consists of only a registrar and a list of persons who might be appointed as arbitrators. Each party to the convention establishing the court is entitled to nominate 4 persons. Only states can be parties before the ICJ. Under Article 96 of the UN Charter, the General Assembly, the Security Council, and any organ of UN and any specialized agency authorized by the General Assembly may seek the advisory opinion on any legal question arising within the scope of their work. While an advisory opinion is given great respect, it is not binding on anybody. The jurisdiction of the ICJ is based upon the consent of the parties to the dispute. The consent given in one form or another. The consent may be given expressly in respect of any particular dispute. If one party sues, the other does not raise any objection to jurisdiction. The court gets jurisdiction by virtue of the principle of forum propagatum. The consent may be given under the UN Charter or under any treaty in respect of any particular class of dispute. Under Article 36 of the Statutes of the ICJ. There is the so-called compulsory jurisdiction under the optional clause. A state may be a declaration declare that it accepts IPSO facto the declaration without the necessity of any further agreement. The jurisdiction of the court as against any state that similarly accepts the jurisdiction by declaration. The declaration may be unconditional or conditional. In order to encourage states to accept the jurisdiction of the court, if not fully, at least partially, it is provided that declaration may be with reservations stated in the declaration. Generally, declarations made by states are with conditions regarding the time when the dispute arises or the category to which the dispute belongs. Reciprocity is an essential condition. Thus, not only the state that makes a reservation regarding any particular type of disputes may claim the benefit of it, but also its opponent before the court. In other words, unless the dispute is within the scope of the declaration of both the parties to the dispute, the court cannot have jurisdiction. The judgment given by the court is binding only on the parties and in respect of that particular dispute. The court frequently cites its previous decision and follows, but this is a matter of practice, and in order to maintain uniformity in the standard of justice, but not as a matter of legal requirement, as in the common law systems derived from English law. European system of law derived from the civil law system have no such legal requirement. Though the jurisdiction of the court is limited, it has given judgments on a large number of cases, along with the opinions of dissenting judges. Many of these cases are not the ones in which the parties would have gone to war to settle them. They have indeed given quietus to the controversies involved. Parties rather seems to prefer adjudication in those cases where the governments concerned do not feel the interest involved to be vital, but would need an authoritative decision to satisfy the domestic public for giving up a claim. Here we want to wind up this lecture. Thank you so much for your attention.